Silent Seniors No More. Episode 3. The clause in Florida law many residents don't know about. What if you rent and you pay every month promises access to community facilities, but one day you're suddenly told that you're no longer allowed to use them? No written notice, no explanation, just a decision. For many residents in Florida, mobile home parks, this question isn't hypothetical. And tonight, in Silent Seniors No More, we're going to talk about a small clause in the Florida law that attorneys often point to when these situations end up in court. Welcome back to Silent Seniors No More. I'm Jaime Ciarla, a resident of Spanish Lakes Golf Village here in Port St. Lucie, Florida. In our last episode, we talked about a pattern attorneys sometimes see when disputes develop between residents and mobile home park management. But tonight we're going to discuss on something even more important. What the law actually says about residents' rights to use community facilities. Because many residents assume management can simply ban someone from amenities whenever they choose. The law may not be that simple. The Mobile Home Act. Florida mobile home parks are governed by Chapter 723 of the Florida statutes, often called Florida Mobile Home Act. This law was created to balance the relationship between two parties, park owners and the residents who lease the land under their homes. One important part of that relationship is the lot lease agreement. Most leases in the mobile home parks include language stating that the resident's monthly rent includes access to the recreation facilities. That can include things like clubhouses, pools, recreation halls, and community kitchens. These amenities are not just conveniences. They're part of what the residents are paying for. The clause that attorneys often highlight: when disputes arise over access to these facilities, attorneys frequently look closely at the prospectus and lease language. In many communities, those documents promise that the residents will have the right to use the park's recreational facilities. Under Chapter 723, those rights generally cannot be changed or taken away arbitrarily. If management limits access to amenities, the action must usually be supported by clearly established community rules, fair and consistent enforcement, and procedures that comply with the lease and state law. In other words, a decision affecting residents' rights usually cannot be made simply at the discretion of one individual. When these cases reach court or mediation, judges often ask a simple question: was the action consistent with the lease and the park's governing documents? If the answer is unclear, the issue can become legally significant. Why amenities matter so much? For seniors living in retirement communities, amenities are not just physical spaces. They are the center of social life. Clubhouses host dinners and dances. Kitchens support volunteer events and fundraisers. Recreation halls allow neighbors to gather and stay connected. In many communities, residents themselves organize the majority of these activities. So when access to these facilities become restricted, it can affect much more than just a room or kitchen. It can affect the entire sense of community. The importance of fair enforcement. Another issue attorneys often examine is how rules are enforced. If rules exist, They generally must be applied consistently to all residents. Selective enforcement, where some residents are restricted while others are not, can raise serious questions and disputes. Again, this is why documentation becomes so important. The timeline of events, the written notices, and witness statements. All these can help establish what actually occurred. Why this conversation matters? Across Florida, more than 1 million residents live in mobile home communities. Many of them are retirees on fixed incomes. Most simply, want to live peaceably and enjoy the communities they helped build. But when disagreements arise between residents and management, the legal landscape can feel complicated and intimidating. Understanding the law, even the small clauses, can make a difference, and knowledge is often the first step toward resolving conflict fairly. In the next episode of Silent Seniors No More, we're going to explore something that many residents don't realize exists: how disputes between residents and park owners are supposed to be resolved under Florida law. There is actually a formal process designed to address disagreements before they escalate, but many residents never learn about it until it's too late. We'll talk about that process next time. Until then, I'm Jaime Ciarla, and this is Silent the Seniors No More, because seniors deserve to be heard.